Hola, buenas tardes. Bienvenidos a esta sesión de contenido que hemos organizado para hablar de la nueva regulación sobre inteligencia artificial. Nos vamos a esperar un par de minutitos a que todos os vayáis conectando, pero para los que estáis llegando, que sepáis que esto se enmarca en el programa de contenidos de Tech Barcelona. Yo soy Paula Serra, llevo todo el tema de asuntos europeos de la asociación. Recientemente, a finales del año pasado, nos unimos a Light for Startups, que es una asociación que representa la voz de las startups a nivel institucional en Bruselas, y hoy tenemos la suerte de tener parte de su equipo aquí con nosotros para que nos expliquen paso por paso cómo va a ser la implementación de este nuevo marco regulatorio de inteligencia artificial y sobre todo qué impacto va a tener en el ecosistema emprendedor y en este caso en las startups. Como sabéis, esta sesión va a ser en inglés. So let me switch to English and introduce you to Inés Moreno, who is the Director of Growth at Light for Startups. Hi, Inés.
Hey, thanks so much for having us. It's such a pleasure.
Thank you for joining us, and also welcome Maxime Ricard, Data Policy Manager at Light for Startups. Welcome to this session of Tech Barcelona.
Thank you for the invitation.
So just for everyone who is arriving to this session and is already connected, you can send us your questions, your thoughts, your whatever you want to talk to them. This is your opportunity, and if you want to keep in contact after this session, we are going to send all of these questions to the Light for Startups team, so don't be shy, share your thoughts. And Inés, Max, feel free to start whenever you want.
That's great. Thank you so much. Well, hi, everyone. My name is Inés Moreno. I'm a Light for Startups very proud director. And we're thrilled to be here today. Our objective as an association is that you startup entrepreneurs don't have to worry about how legislation is made. And we hope to do that successfully. But it is true that in the case of the AI Act, it's a very complex regulation, and I'm sure you're all very curious to hear how it's going to impact the startup ecosystem. Just the one thing that I want to say here is that it's incredibly important that startup entrepreneurs like yourselves are part of communities such as Tech Barcelona, because you shouldn't be worrying about how regulation is going to affect you or how it's going to affect you in the future, but it does. So having someone that represents you at that level, I think it's really important. Then our mission at Light for Startups is to take all of the associations as Tech Barcelona to speak on your behalf. I'm no expert on AI, and Max will have me say that he's also not an expert, but he's the sort of in-house nerd, and he's really great at it. And I'm very excited for him to talk to you. What we will say is that we represent the startup ecosystem as a whole, rather than we're not consultants. We don't know how every specific piece of legislation will affect a specific startup, but we want to give you an overview of how this more or less is being shaped and what the process is like. And happy to answer any questions that you may have and that we can answer. So with that, thank you so much again, and I leave it to Maxime.
Thank you so much, Inés. Yes, all right, you can see the presentation. So yeah, thank you everyone for being with us today. Thank you very much, Paula, for giving us the opportunity to talk about this very interesting piece of EU legislation. My name is Maxime Ricard. I'm a Light for Startups new policy manager, and I'm mainly working on AI. So perhaps not an AI expert, but an AI enthusiast, that's for sure. The AI discussion is a very timely one because, well, as you may or may not know, this is being discussed heavily at EU level as we speak. And it's also a very technical conversation. So I'll just do my best to be as understandable as possible. It's a bit like Belgian politics, basically. If you finally understand the AI Act, it's because it hasn't been explained clearly enough. So good luck. I'll really do my best. Just before we start, I don't know whether it has been said or not, but I will try to make sure that the presentation doesn't last much more than 30 minutes. And yes, obviously you can ask your questions after the presentation orally or in written. So grab a coffee, make yourself comfortable, and let's go for the AI Act then. So for me to talk about the AI Act, I divided my presentation into 3 blocks. First of all, I would like to talk about the AI Act itself, break it down for you. So basically speak about the approach that underpins the AI Act, the requirements and obligation for high-risk AI systems, because that's, I think, the most relevant things to be discussed and explained to you. And also, I will want to touch upon the innovation and enforcement provisions of this really important legislation. Second of all, I would like to talk obviously about the relevance for startups and what our priorities are regarding this AI Act. And finally, I would like to try and see what could be the next steps, because there's not many options right now as we speak, but there will be many more in the future as the file will enter trilogue, so interinstitutional negotiations between the 3 institutions. But I'll come back to that later. So let's start with the AI Act itself. So the AI Act is a legislative proposal that was proposed by the European Commission on the 21st of April 2021. I really want to insist on the fact that I'm going to talk about the Commission text, not the text that's been agreed within the EU Council, and not the text that's been discussed by the European Parliament. So really talking about the proposed version of the European Commission. Why have a discussion on the AI Act? Because it has the potential to set a global blueprint. You may have heard about the Brussels effect. So basically, when the EU adopts something on the AI Act, for instance, it's likely to be replicated in other countries and regions of the world. So it's relevant for you because it might apply to you in Europe, but it might also be relevant to your operations if you ever want to exchange and trade with other regions of the world who actually apply AI-related legislation. Now talking about the scope, because obviously we need to define what we're talking about. So the scope of application, so it applies to public and private actors operating inside the EU, but also outside. If for instance, the AI systems developed by foreign companies are deployed in the EU and affect people in the EU. But what I really want you to understand is the 2 types of actors that are actually really likely to be impacted by this AI Act. First of all, they are the providers that we could also call developers. I think it's easier to call them developers, to be honest. And then there's the users, the people deploying the AI systems. So I put a short example in my presentation, as you can see. So for instance, the provider of an AI system could be someone developing a CV screening tool, whereas a user will be, for instance, a bank or another type of organization buying and using this CV screening tool. So yeah, just for you to understand the difference between the 2. Now, when we're talking about the AI Act, what are we talking about when it comes to the approach? Well, instead of focusing on regulating AI according to the specific sector in which it was used, the European Commission opted for a risk-based approach. Some would say it's the worst option. I personally think it's the best option amongst the worst options. But some AI systems, it's just for you to understand that AI systems will be regulated according to the level of risk they pose, and they are divided in this regard in 4 different categories, as you can see on the slide. So just for you to understand, the 4 categories are the following. First of all, the one with unacceptable risks. Second of all, the one with high risk AI systems, the core of the legislation. Then AI systems with limited risks. And then the last category, the rest, basically, is everything that's not regulated and that pose minimal to no risk at all. So let's break it down really quickly. It's actually fairly simple. The first category, the unacceptable risk one, is everything that's prohibited. So everything that the AI Act, for which the AI Act says that it's completely unacceptable, it poses unacceptable risks, is outright banned, and it includes actually social scoring, facial recognition for law enforcement purposes, everything that affects vulnerable groups and uses subliminal techniques. This is a really vague wording. I'm not sure it's really relevant to spend too much time on that. Just keep in mind that this is something that's prohibited, and I'm not sure it's exactly relevant to what startups do, because startups rarely develop or deploy social scoring systems like in China. At least I don't think so. The second category is the most important one for you to understand. So it's all the AI systems that are deemed high risk. All of these systems will need to comply with really strict requirements. Now, how do you know that your system is a high-risk AI systems? Well, it's on the right side of the slide. There are 8 areas listed in the AI Act. Just taking one, for instance, the fourth one regarding employment. Well, the CV screening tool would be actually a high-risk AI system because it's used within the context of employment. Right? I'll come back to that later because obviously we need to talk about the requirements and the related obligations. So let's go to the third category, the limited risk category. In this category, you will find all the AI systems that only need to deal with transparency obligations. So for instance, chatbots and deepfakes. So that the AI Act wants these AI systems with limited risk to only disclose that they are AI systems. So basically, it's just a chatbot telling you you are interacting with a chatbot, a deep fake telling you, hey, by the way, I'm not real, I'm not a real image. So that's really simple. It's one article only. And I think you should also keep an eye on this one because I assume that some of the apps that you might develop as startups could fall under that category. The last category is actually the simplest one, is the one, it's I told you all the rest, and it's completely not regulated. There is a few provisions in the AI Act talking about these ones, just to tell us that it's not going to be regulated and to potentially encourage companies to draw up codes of conduct, so voluntary legislation, voluntary agreements. All right, so if this is understood, then my job is done almost, at least half done, because this is the architecture, the main architecture of the AI Act. So if you understood that, congratulations, you've done half of the way. If you have any questions, please do not forget to ask them at the end. I'm really happy to answer them. So okay, now going to the requirements and the obligations for high-risk AI systems. So remember, it's the second category with the 8 areas, like the CV screening tool I was mentioning earlier. So for that, you've got requirements. For these high-risk AI systems, you've got requirements, and these requirements are actually related to specific obligations for providers and users of high-risk AI systems. Now, just to make sure that you understand the requirements themselves, well, there they are. So before a high-risk AI system is placed on the EU market, this high-risk AI system should undergo a conformity assessment carried out by the provider, the developer, if you will, of the AI system, the high-risk AI system, to check it is compliant with several requirements, which are the requirements that you see on the slide. So I'm not going to go through all of them, but just taking one of them as an example. For instance, the second one, the high quality data sets one, it's the one related to data and data governance, and it wants to ensure that before a high-risk AI system is placed on the market, it has a data set of high quality, feeding the system to minimize risk and discriminatory outcomes. That's what it wants to do. So that's just one example of a requirement for high-risk AI systems. So just keep in mind that this needs to be complied with ex ante, so before the placing on the market. Now going to the obligations for the providers, so which are completely linked with the requirements I just showed you. Here is the list of all of them. And the first of these obligations is obviously to be compliant with the requirements for high-risk AI systems I just mentioned. As you can see, it's really related. You've got the obligation to draw up the technical documentation. It was something that we just saw in the requirements. So everything that you see in there is somehow related to requirements and makes a lot of sense, obviously. Just a couple of words on the conformity assessment, because I told you that it needed to be checked ex ante via conformity assessment. If you are indeed a provider of a high-risk AI system and you need to comply with all these obligations and the requirements I just presented, you might need actually to go through either a conformity assessment based on internal control, so actually a self-assessment, or a conformity assessment based on something that will be involving a notified body. So a notified body is a body that is notified and designated by a national authority. This is where it gets really technical, so I'm not going to spend too much time on that. We can leave the floor open for questions about conformity assessments, but just keep in mind that you need to do a conformity assessment if you are a provider of a high-risk AI systems and comply with all these obligations and the requirements for AI systems. Now, if you are a user, so a deployer of high-risk AI systems, as you can see, you have essentially less obligations to comply with. But again, that doesn't mean that you cannot be considered a provider, because as you can see in the little text box, any user, any deployer of a high-risk AI system can be considered a provider and hence have the same obligations as a provider if you either place it on the market under your name or trademark, if you modify the intended purpose, or if you make a substantial modification. Then at this stage, it could be considered that you act as a provider and hence have all the obligations that a provider has, okay? Again, if this is understood, then congratulations, you have understood, I think, more than 50% of the AI Act, and that's amazing. Now, the last part of the AI Act I wanted to explain is everything that's related to innovation and enforcement. The AI Act, when it was proposed by the European Commission in 2021, was based on two pillars. One called, I think, was something like trust. It was based on trust and safety. So basically make sure that people could trust AI. So this is where we started talking about trustworthy AI systems. And the second pillar on innovation and making sure that companies had an incentive to actually innovate in that field. So the Commission did not forget about the innovation, because the Commission drafted several articles on sandboxes and the AI board, for instance. Just let me break it down for you. So basically, the sandboxes, for those of you who are not familiar with sandboxes, it's an environment, a controlled environment in which you can experiment, in which you can test your system. And there is one big article in the Commission proposal on sandboxes, and actually startups are mentioned in that article. They should have priority access. This is, again, really vague. Fortunately, perhaps I'm already anticipating the questions, but fortunately, the text of the European Parliament is actually way more positive for startups and less vague, clearer, so that's good news. But also in the Commission text, sandboxes are not harmonized at EU level. I mean, it's not mentioned at all how is it going to be done at EU level. That's for sandboxes. Now, regarding the enforcement, because I think this was also a concern of the industry and of startups, basically the national competent authorities, and again, I'm remaining vague not to go into too many details, but the national competent authorities would supervise the application and the implementation and would carry out market surveillance activities. So that means that besides the ex-ante requirements, they will be an ex-post surveillance of the activities by market surveillance activities. Just keep that in mind. And lastly, regarding innovation and enforcement, the Commission draft foresees the creation of a new body, a new entity at EU level that would be called the AI Board. And now, it might not be the final name of that EU body, might be called AI Office, we do not know yet, but this AI body, this AI Board, would basically be there to coordinate, guide and assist the national competent authorities and the Commission when they apply the legislation. So it would be composed of the national surveillance authorities, the European Data Protection Board with all the EU TPAs, and the Commission. What's interesting in there for you is that it is written in the Commission draft that the AI Board may invite external experts. So opening the door to input, for instance, coming from the startup community. Again, this is really vague in the Commission text, but it's really much improved in the EP version. So now coming to the relevance for startups and our priorities, the priorities that we have identified when reading the Commission text. There are 5 of them. First of all, the requirements for high-risk AI systems. For us, that's the core of the legislation, and it is actually the core of the legislation. So our main goal here is to make sure that these remain as clear and as achievable as possible. Otherwise, startups, they won't be able to thrive and innovate. If the responsibilities are not clear from the beginning, well, this could disincentivize entrepreneurs from developing AI systems in the EU. So this is really the first priority for us, and we are keeping an eye on it, obviously. The second one is the conformity assessment procedure. So you saw that I wanted to talk about that, but I did not have enough time to talk about that in detail. But it's actually a really relevant and important part of the AI Act. For us, we think that conformity assessment procedures should take into account the startup innovation model. Oftentimes, the startups do not have the financial runway to wait several months for to get their AI technology approved. So the conformity assessment procedures for us should be clear, but also straightforward. And the time frame to get the approval should be really as fast as possible in order not to undermine the competitiveness of the startups working in high-risk areas. So you can see that it's actually something quite technical, but we need definitely to have a look at it. The third point is the sandboxes. I already touched upon them in my previous slide. For us, the sandboxes framework should be designed and implemented across all member states in a harmonized manner. This is why I put the emphasis on the fact that it wasn't harmonized, because it isn't. Why is it important to have a harmonized EU framework for sandboxes? Well, because we want to make sure that the navigation of sandboxes is facilitated for startups. Startups often move locations, they pivot their businesses. So having a harmonized framework for sandboxes is really key. Startups should be able to find identical or at least equivalent sandboxes in the different member states. That's really key for us. Fortunately, as I told you, the EP text is way more positive because it actually mentions startups. So at least we have a lot of improvement in the European Parliament's text on this. The fourth priority that we have is the European body on AI, so the AI board I also just mentioned in my previous slide. For us, it should be not only inviting potentially external experts, but it should be composed of a team of relevant and diverse AI experts. And when we say diverse AI experts, we actually want to say experts who are let's say, who know a bit about the startup ecosystem and the startup's business models, basically. So we really want to make sure that the experts are going to be somehow involved in that European body on AI know about startups and their needs. That's really key to us. Again, the EP text is way more positive on this aspect. And the fifth item and the final one is the one on general purpose AI. So I'm a bit opening Pandora's box here, because general purpose AI is not in the Commission's proposal. It was not mentioned, and it's actually understandable because the AI Act regulates AI systems as soon as they have an intended purpose. When we talk about general purpose AI systems, well, this is not supposed to be regulated. But you may have heard of ChatGPT. Obviously, this new development sparked a lot of debates in the EU, and the European Parliament thought it was relevant to include a whole article on foundation models, which is basically a sort of general purpose AI in its text. So they have an entire article dedicated to that, with specific obligations for generative AI systems. Well, what I want to say on that is that for us, for the startups, I think it should not be over-regulated, if not regulated at all. It was not the purpose of the AI Act in the beginning, and now the EP, because of ChatGPT and all those generative AI systems, wants to regulate it. But if it is eventually regulated, and I think it's likely to be regulated, let's be honest, because there is a momentum for that. We really want to ensure that this is not over-regulated. A lot of startups are using general purpose AI, like, I don't know, speech recognition, things that actually help them scale. So it's really key to us that this is not over-regulated. That's it for the relevance for startups. Now, quickly wrapping up on the state of play and the next steps. So just to remind you that the text is not final. So everything I just explained is based on the Commission's proposal, which was proposed, as I told you, 2 years ago. Now the Council has agreed internally, so within member states, on a general approach. So they have their version of the text. Now the EP has to vote on the 14th of June, so in 2 weeks now, on their final version. And as soon as this is done, the three institutions, so the European Parliament, the Commission, and the Council, will discuss within closed-door negotiations, within what we call the trilogues. All of that, just to tell you that should this enter into force, it should be, and please, it's only, do not mark my words because it's only to be confirmed, but it should enter into force in 2024, 2025. So we'll see how this plays out. But for now, we are waiting for the plenary vote and for the trilogues to start on this. Thank you very much for your attention, and yes, please send me your questions.
Thank you so much, Max, for this quite insightful and useful explanation. We have a few questions that we have received during your explanation. The first one is from Maripao that says, hi, could you elaborate on the ethical considerations addressed in the AI Act? I think it's more linked with the general purpose AI that you were mentioning right now when you were ending your presentation, that I think that right now it's a hot topic, everyone's talking about it. So I think that sometimes ethics and transparency or general purpose gets mixed in the same debate. So I don't know if she's asking me for your point of view, or what are the main considerations to take in mind.
Well, it's an interesting question actually, because when you think about, when you have a look at the AI Act, it's a really product safety regulation. So you could think, okay, it's product safety, so it has nothing to do with ethics, but it's actually the contrary. When the Commission proposed the AI Act in 2021, they did it, and they really took an informed decision, because within the European Parliament, there had been a lot of debates on AI and ethics. There was even an EP resolution, I think it was in October 2020, on ethics of AI and robotics, I think. And just, it was a non-legislative initiative from the European Parliament, but this actually created like, so not really a bucket list of principles, but almost. And I mean, in there was like privacy, safety, transparency, accountability, having a human-centric regulation as well, and making sure that there wasn't some sort of EU-wide coordination when it came to AI. So ethics, ethical consideration are translated into the AI Act because of this report specifically. And you can actually see that within the requirements. All the requirements for a high-risk AI system that I just presented, many of them rely on those principles. Many of them want to achieve transparency, want to achieve accountability, safety. The AI Act is really underpinned by these ethical considerations. Now, just to talk about general purpose AI and the ethical considerations around that, the debate has not only started, but it's quite a recent debate. So now the European Parliament, when they introduced their article, they were a bit fast when they did that, because I don't know whether you had a look at the text, but it's one big article. It's really drafty. It takes requirements from the high risk category, but not all of them. So it creates eventually a fifth category of AI systems to be regulated. And regarding the ethical considerations there, it draws on the high-risk AI system. So the ethical consideration that you see in this article on general purpose AI are actually a bit the same that you can find in the high-risk AI systems category.
This leads me to another question that we have received through the streaming website. Maybe there's a relation, maybe it's another topic, but they are asking, technology is moving very fast. The EU effort seems to be more focused on defining what AI is. But what do you think that, do you think that this regulatory framework maybe could become obsolete with the emergence of new applications of AI? I think it's quite linked to what you were saying. I mean, right now the hot topic or the most recent debate is ChatGPT, chatbots, DALL-E, generative AI, but maybe in a few years we're going to see, or next year, in a few months, we're going to see new applications. It's not just new technology improvement, it's new applications of AI. So could this framework be obsolete if it just takes in consideration the high risk or the risk approach?
Yeah, I think that's a great question once again, because indeed, the goal of the AI Act was to be a horizontal framework, so something that would be future-proof. The EU is the first body that is proposing a binding regulation, a comprehensive and binding regulation on AI worldwide. And I think in this regard, the EU should be specifically careful with how granular it wants to go. So yeah, indeed, I think there is indeed a real danger for the legislation to become obsolete, but also to be too specific. I just mentioned this article about general purpose AI that takes inspiration from the high risk category. And again, to be honest, I understand it because I think policymakers want to, it's a bit of a statement for them. They really want to make a point. But I actually disagree with it, because that's not the purpose of the AI Act. The AI Act is meant to regulate AI systems once they have an intended purpose, not general purpose AI systems. So indeed, I think this point is perfectly relevant. Indeed, it might have implications in the future and it might become obsolete.
Okay, that's really interesting. I think it just talking about this topic could lead us to have a specific session just on general
definitely.
AI. Now we have a question from Miguel Gaspar that says that you mentioned that the sandbox framework is where startups are placed right now in the AI Act. Do you think that's enough? Should he take into account that other perspectives to address the AI Act?
Sorry, the question is about whether the startups data sandboxes are relevant?
Yes, I think it goes that way. I mean, at the end, it's if the AI Act consider startups replace startups within the framework of sandboxes to be able to innovate, to try in a more controlled environment? Do you think that startups should take into account other perspective or approaches to understand the AI Act, or at the end take advantage of it?
What is really interesting right now at EU level is, as I already said a couple of times during the presentation, the European Parliament's provisional agreement that needs to be adopted on the 14th of June is actually considering startups way more than the European Commission proposal. So that's really an improvement for us. We can actually be really glad about that. For instance, and that's the main improvement regarding sandboxes and startups and how they are considered, it is now clearly written in the EP provisional agreement that the sandboxes should be free of access for the startups, which is amazing that the wording allows that for us. So yes, I think there's a lot of improvement, and if you again have a look at the EP provisional agreement, you will see that it's not the only place where startups are considered and where you can really feel that the EP wants to make sure that the startup model is taken into account. In like many parts of the legislation, startups are mentioned, and they are positively mentioned in order to help them. There is even a whole article on making sure that startups and SMEs are shielded from unfair commercial practices. So yeah, there's actually a lot of improvement, and the startup model is being more considered in the EP provisional agreement.
Okay. So we have two more last questions. If somebody else wants to share their thoughts, or even one personal case, or explaining how your startup is doing and how it's going to be placed into this AI Act, please feel free. We have like 10 minutes left. But just to keep going, another question from Michelangelo that says, how can research labs or consultancies leverage the AI Act as a source of business opportunities? I think it's more focused on research labs. I don't know if it's quite easy or if it's complex, or if you have a statement on that.
Yeah, that's an interesting question. I wish I had the answer. No, but I think it's actually a bit more. What's positive with the concepts of the AI Act itself is that it really wants, and hopefully will achieve, it really wants to give legal certainty to businesses. Of course, it will heavily depend on the final version of the text and whether or not, like we said, it will manage to provide a horizontal and future-proof framework. And I think only if the final text achieves that, then they will have business opportunities because of this legal certainty that the final text is giving businesses in Europe. So yeah, that's the only thing I can say about that. I think it will be up to the businesses to find the business opportunities within that.
And now one last question that it's more regarding to the GDPR requirements. And it says that how can businesses ensure that their AI systems and practices align with both the AI Act and the GDPR requirements?
You saved the most difficult question for the end. No, that's actually, I think, within everything that you've asked, and that the people have asked, I think that's perhaps the most relevant question. A company will need to comply with both the GDPR and the AI Act, because AI systems, some of them, not all of them, but some of them, like generative AI, for instance, use personal data. So obviously there will be an overlap between the two legislation. The GDPR is actually mentioned a couple of times in the original text of the AI Act. If you have a look at the principles that we just mentioned, so transparency, accountability, fairness, I don't think fairness is mentioned in the AI Act, but there's a lot of common principles between the AI Act and the GDPR. The only thing that is perhaps not exactly extremely positive is that these principles, I think, are interpreted a bit differently according to the legislation. So if if I was actually if I were the legislator, I would actually make sure to define those principles as to make sure to give as much legal certainty as possible for businesses, because as it is defined and interpreted right now in the AI Act, it's different from the GDPR. So in my opinion, I think the AI Act tries to align with the GDPR because it provides the same principles, but it defines them in a different manner. So I think it will be up to the institutions to make sure that eventually those principles are not only the same, but also interpreted in the same manner.
Yes. Okay, so I think that's it. We don't have any more questions. If someone wants to ask Max or something else, feel free to reach us out and we'll connect you with them so you can have a more insightful conversation. But Max, thank you so much for your time and for explaining.
Thank you for the invitation.
All of that. I think it's a topic that we are going to keep talking about for the upcoming years. So, thank you so much. See you soon. Y muchas gracias a todos los que os habéis conectado a esta sesión con Allied for Startups. Desde Tech Barcelona somos partners de esta asociación. También estamos muy orgullosos de poder estar representando la voz del sector a nivel europeo. Estamos muy centrados este año siguiendo el AI Act y Data Act, sobre todo, pero también estamos encantados de recibir propuestas, comentarios, preguntas que tengáis alrededor, intentar siempre dar respuestas. Así que muchísimas gracias y nos vemos pronto. Bye bye. Thank you.
Adiós.
Thank you. Ciao.
Ciao.